Realty Company, LLC. Sitting in place of Justice Fisher this morning is Judge Robin Piper from the 12th District. And in place of Justice DeWine, we have Judge William Klatt from the 10th District. Welcome, judges.
Good morning. Thank you.
For the appellant, we have Mr. Manning.
Yes, Your Honor.
You may proceed.
Thank you. Chief Justice, may it please the court, good morning. I'm Mark Manning on behalf of Appellant City of Cincinnati. I would like to request 3 minutes for rebuttal. The First District erred when it held that service on the Attorney General pursuant to Revised Code 272112 did not have to be completed at the inception of the case. In reaching its decision, the First District ignored the text as well as the purpose of the statute and this court's precedents in Chico versus Stockmeyer. When a party fails to serve the Attorney General at the inception of the case, it deprives the Attorney General of having a meaningful opportunity to participate or be heard, and is inherently prejudicial to the Attorney General as well as the parties. For those reasons, this court should reverse the First District Court of Appeals and hold that service on the Attorney General pursuant to Revised Code 272112 must occur at the inception of the case. In 1933, the General Assembly passed the statute that would later be recodified as Revised Code 272112 as part of the Uniform Declaratory Judgment Act. And in 2000, this court in Chico versus Stockmeyer had the opportunity to interpret that statute and specifically what was required in terms of the timing as well as the service on the Attorney General. And this court held in Chico that it was necessary for there to be jurisdiction for the Attorney General to be served consistent with Civil Rule 4.1 and for that service to occur at the inception of the case. And to reach that conclusion.
You keep saying the inception of the case, but you would agree that it's also when the constitutional issue is first raised, correct?
Correct. The language inception of the case is the language that this court used in Chico and subsequently in the Mayer versus Bristow decision as well. And I believe it first arose in the Citizens for Fair Representation versus Taft, where the issue of service on the Attorney General came up in that case as well. But the language that is used or the purpose is to assure that the Attorney General is notified at the earliest opportunity in the case, and so that the Attorney General has a fair opportunity to participate and make a determination.
But Counselor, the Attorney General did have an opportunity to participate and decided not to in this case, right? So where's the harm?
So correct, the Attorney General did have the opportunity, but this court was clear that in Chico it wasn't enough to have an opportunity, that it had to be a meaningful opportunity to participate in the case.
So shouldn't it be the Attorney General that asserts the lack of a meaningful opportunity?
Well, no, Your Honor, because this court has been clear going back to the 1970s that the requirement of service on the Attorney General is a jurisdictional requirement, and that serving the Attorney General and giving the Attorney General that opportunity to be heard is necessary to establish the court's jurisdiction, which means that it can be raised by any party at any time, including the court sua sponte.
Counsel, when did the issue or the need for the Attorney General's notice come about?
When was it first raised, Your Honor?
What was the trigger that would have included the Attorney General?
The counterclaim, which was filed by Fourth National in this case, I believe it was early on in the case in 2015. This case progressed for 2.5 years before the Attorney General was actually served. But the late service on the Attorney General does have an impact both on the parties as well as the Attorney General. The first issue, as I was alluding to with Justice Stewart, was that there's a jurisdictional problem that's created when the Attorney General is not served at the inception of the case. This court has been clear since the 1970s that it's a fundamental requirement in a declaratory judgment action to serve the Attorney General, and that in the absence of serving the Attorney General, there's no jurisdiction to act, which means that—
What's your precedent for using the word jurisdiction? I mean, clearly the Attorney General, even if he had been served from the outset, as you said, could have at that time decided it's not necessary for the Attorney General to be a part of this. And so that to me suggests that it's not jurisdictional. We might want to talk about prejudice, but what's your precedent for using jurisdiction?
So this court in Malloy versus Westlake in 1977 said that it's a jurisdictional requirement and has held to that requirement through a number of decisions since that decision in Malloy, both in Chico as well as I think subsequent to that in the Mayer versus Bristow case as well. So there's a series of precedents by this court that recognize that it's a jurisdictional requirement to serve the Attorney General.
So what do you really win if this court was to decide that it is jurisdictional? It would just go back to, and we reversed, wouldn't it just go back to that first counterclaim that was filed, and then wouldn't the path be exactly the same as what occurred?
No, Your Honor. Well, this case has progressed for 2.5 years. And so over the course of those 2.5 years, the various aspects of the case has been litigated and various aspects of the case have been decided, including the trial court actually issued a substantive decision early on in the case about the declaratory judgment claim, the counterclaim, finding that the city's ordinance was in fact constitutional under the Central Hudson test. But the various other claims that have been asserted both by the city and Fourth National have been resolved. And so the only claim that remains, I believe, at this point is the declaratory judgment claim, which Fourth National, according to the decision by the First District, can pursue an as-applied challenge to the ordinance with respect to a sign that they wish to erect on their property. And so if the city were to win here and that the court would decide that the failure to serve the Attorney General at the inception did deprive the Attorney General of having a meaningful opportunity to participate or be heard, then the case would effectively be over, although I do think Fourth National would potentially be able to refile based upon the claims that it has remaining at this point. But it would dispose of the case. Unless this court would agree with the First District, then of course, the case would be remanded at that point for further litigation on that declaratory judgment claim. But this case in many ways is an excellent illustration of the prejudicial impact that can occur both on the Attorney General as well as cities or other jurisdictions that are defending cases similar. And as I indicated—
Counsel, was there prejudice here? I mean, the Attorney General obviously has the option to opt out. Is that correct? So they are dispensable for the case.
Correct. And Your Honor, the First District concluded that there was no prejudice, but there was frankly nothing in the record or with regard to the arguments of the parties about whether or not the Attorney General or the parties were prejudiced by accepting service late. And so the Attorney General, the only communication that's in the record is the letter which was sent by the Attorney General to the parties that was filed.
Whose burden is it to show prejudice here?
Well, Your Honor, since it's a jurisdictional requirement, it's on the party asserting that there is jurisdiction to establish that there is jurisdiction. So in this case, it would be Fourth National. And there's nothing within the communication from the Attorney General which indicates whether or not there was any prejudice. And in fact, there was a statement in its notice to the court which stated that that no assumptions should be drawn regarding its declining to participate beyond the fact it was declining to participate. Despite that fact, the First District concluded that there was no prejudice.
Well, Counsel, wouldn't that statement go to both a statement as to the merits of the case as well as any prejudice?
No, Your Honor, because the representation made or the comment made by the Attorney General was that they were declining to participate in the merits of the case and that the parties should not, the court should not draw any inferences from that beyond the fact that they were declining to participate. So that would include whether or not they were prejudiced. And if you look at the procedural posture with which they were notified, I think that illustrates very effectively the prejudice, because in this case, the Attorney General was notified almost 900 days into the litigation where there were cross motions for summary judgment which were filed and then decided by the trial court, where the trial court rendered a substantive decision finding the city's ordinance to be constitutional. That was then appealed.
What was the city's response when the Attorney General declined to participate?
I'm not sure if I understand your question, Your Honor. Are you asking if the city?
When was your jurisdictional challenge filed?
The city raised the jurisdictional issue prior to service occurring on the Attorney General. So the issue was raised during the city's second motion for summary judgment, which was about two and a half years into the litigation. At that point, Fourth National attempted to serve the Attorney General a couple of weeks, I believe, after the issue was raised. And the Attorney General, while it was served a few days before the city's motion for summary judgment was ripe, the parties didn't know when the motion became ripe, whether or not the Attorney General would choose to participate or be heard in the case. But by the time that the Attorney General did, in fact, indicate that he was declining to participate or be heard in this case, the case had proceeded so far along that the parties, that the city's motion for summary judgment was ripe. Both parties had filed their pretrial statements and they were just a few weeks away from trial. And so the Attorney General was put into the position of having to decide whether or not to intervene in an action that had been pending for 2.5 years, where a summary judgment motion was days away from being ripe for decision, and the Attorney General would have to insert itself into that and or have to be prepared to go to trial in a few weeks. And that would be prejudicial.
Let's take it away from this case. I mean, in this case, the Attorney General said, we're not going to participate. So let's take it into a hypothetical situation where maybe there was this long period of time, maybe there would be some perceived prejudice. Couldn't a trial court fix that? You know, I mean, you could fix it in a number of ways. You could grant a continuance. You could order sanctions against the party that failed to notify the Attorney General in a timely way. Why couldn't you fix whatever prejudice you might be thinking of?
Well, that would certainly fix the prejudice for the Attorney General, but it would still impose a prejudice on the party that's defending the action to have to relitigate aspects of the case for which there is no jurisdiction. So in this case,
couldn't the court address that as well? Couldn't that, and that's where the sanction might come in, to say, now you're going to have to, you know, you failed to give a timely notice to the Attorney General, you're going to have to pay fees.
I suppose that could occur, but ultimately the purpose of this, I see my time is expiring, if I could complete my answer for you, Justice French, is that the purpose is to put the Attorney General on the same footing as the parties in the case. And if the
why is that the purpose? Isn't the purpose to give the opportunity for the Attorney General on behalf of the state of Ohio to defend? That's the purpose, is to defend the constitutionality of a state statute. So
I would
go ahead.
No, I would certainly agree with you, Your Honor, that is the purpose. But as this court was clear in Chica, that includes that there be a meaningful opportunity to be heard. And this court has consistently held through its precedents that notifying the Attorney General at the summary judgment phase is simply too late for that meaningful opportunity to occur.
Counsel, why did the city wait to summary judgment stage to raise this jurisdictional challenge and not raise it in the answer, the counterclaim?
Your Honor, it wasn't recognized by the city until the late date, but I would submit that it is the party who is responsible for establishing jurisdiction to complete the service. And so it's not the city's responsibility to raise the issue as much as it is Fourth National's to ensure that there is jurisdiction for the court to render a decision on its claim.
Well, wouldn't a ruling in your favor encourage gamesmanship if you know about this defense and the other side doesn't, and you just wait, like you said, it happened 900 days or so into the litigation, and then springing it on them that they missed this notification requirement?
No, I think the opportunity for gamesmanship exists if parties don't have to establish jurisdiction early on, and if the Attorney General doesn't get notified or the issue doesn't get raised, there's the possibility that decisions are made that the Attorney General just sits with until potentially years after judgment. And then the issue is raised and says, well, there's never any jurisdiction for that case because the Attorney General is never notified. And so the possibility exists for gamesmanship in that respect as well.
Counsel, you're presuming prejudice without evidence, correct?
Correct. There is nothing from the Attorney General which indicates that they were prejudiced in this case.
And the city is not saying, gee, you know, we can't do this without the Attorney General at our side.
Well, without representing the state, from the city's perspective, many of the claims that are raised in this case do have an impact on the state. So I think the state has an interest in participating in this case.
Well, sure, but that's up to the Attorney General. I'm saying the city was not left without resources or a path here because the Attorney General decided not to join.
That's correct. We're just forced to relitigate an aspect of the case which was already decided.
All right. Thank you.
Unless there's any, thank you, Your Honor.
Mr. Holzapfel? You'll have to turn your mic on, sir.
Okay, can you hear me now?
Yes.
Yes, yes.
Okay. Eric Holzapfel for the appellee. 272112A sets forth three objective requirements. One, that we serve the Attorney General a copy of the complaint. Two, that we do it pursuant to 4.1 of the Civil Rules. And three, that the Attorney General shall be heard. We did all that. All of that happened. We met all three requirements. There's no dispute about that. And the First District Court of Appeals agreed and said that we met the requirements of the statute. I think it's well settled that when a statute is clear, and I believe this statute is clear,
Does the statute address the timing of that notice, that service?
The statute does not address timing of the notice.
It's unclear as to the timing, correct?
Well, I'm not sure it's a clarity question or an omission by the legislature, Your Honor. They had two chances.
But then how do you deal with Sitco? How do you deal with Sitco that interprets the statute and says that it shall be at the commencement of when the constitutional issue is arrived? In other words, subject matter jurisdiction is a creature of statute. And then Ohio Supreme Court has interpreted that statute on two occasions and indicated that because the wording in the statute is mandatory, that it is related to jurisdiction. So how do you deal with those two Supreme Court cases?
Well, let's look at Chico first. The holding in Chico does not reference when the holding I'm talking about does not reference the timing. If you look at the holding, it says that we hold that a party who is challenging the constitutionality of a statute must assert the claim in the complaint. We did. And he must serve the pleading upon the Attorney General in accordance with Rule 4.1.
It goes on to say, or at the beginning of the action or the initial pleading stage in which the constitutional challenge is raised.
Well,
here,
I don't see that in the holding, Your Honor.
Judgment.
I'm looking at the Chico case, and I'm reading from the Chico case, and I'm reading what the court said was their holding. They did. There's no question that the court talked about raising it at the inception of the case. I don't know that adds a lot of clarity. I'm not sure when the inception of a case is. I don't know that adds anything to the statute. I think
doesn't a case occur when it's filed?
A case does occur when it's filed. And you'll notice that the dissent, and there were three judges that dissented in Chico, Douglas, Pfeiffer, and Cook, raised the point that the statute not only refers to the action, but it talks about the word proceeding. If you look at the statute itself, it says that the Attorney General shall be served with a copy of the complaint in the action or proceeding and shall be heard. So a proceeding, according to three judges in the Supreme Court, a proceeding is broader than the term action. And in fact, a motion for summary judgment is a proceeding according to those justices.
And they only needed one more to make that a holding, but they didn't have it. That's a dissent.
They didn't, but I think that they pointed up the fact that we should give effect to all words in a statute, and proceeding is one of the words that the legislature picked, and so if that is correct, this was raised in a motion for summary judgment proceeding. That's when the first was raised. It was not raised at the inception of the case. Could have been raised by a 12B1 motion. Was not. I don't know if there's gamesmanship involved in this or not. I'm not saying one way or the other, but this case was decided by summary judgment, went to the Court of Appeals, reversed, back to the trial court. Another summary judgment motion was filed, and 2.5 years after the filing of the counterclaim, the city suddenly decides that there's a jurisdictional element to this. And they raised it, and we responded to it, and the Attorney General was heard. The Attorney General responded and said,
well, that brings me to another question. If subject matter jurisdiction is a creature of statute, and if two previous Supreme Court cases, and I noticed that you didn't address Malloy versus Westlake, which clearly says it's jurisdictional because of the mandatory language in the statute. Is prejudice something that can confer, take away, or grant jurisdiction? Either you have subject matter jurisdiction or you don't. Isn't that the case?
Yeah, Your Honor, I'm not arguing prejudice. I don't think anybody was prejudiced here. The city wasn't prejudiced. They offered nothing to show that. The Attorney General wasn't prejudiced. Frankly, I think it's up to the Attorney General by this statute. And this, perhaps nobody in these rooms would have written this statute this way. But the legislature did, and they passed on it twice. And they had an opportunity to say in this statute, you've got to serve the Attorney General at a specific time. For example,
and when they amended the statute, they added the word complaint, didn't they? Doesn't that indicate that they wanted it to be at the inception?
Not necessarily, because it says serve a copy of the complaint in the action or proceeding. There's two different words there, and I think you have to give effect to both of them under statutory, well-settled principles of statutory construction. And a motion for summary judgment is a proceeding, and it was raised and the Attorney General was heard. And I think that's all the statute requires. When we start trying to add words to the statute, I think you create maybe more problems than you solve. And in fact, I'm not sure you add clarity. The Supreme Court has mentioned in Chico, inception. By the way, the Malloy case is distinguishable because the Attorney General was never served. But the
counsel, the counterclaim was made, and even after that, it was some time before the Attorney General was notified, correct?
Yes, Your Honor.
Were you the attorney at the time?
I have been the attorney from day one.
Okay, is there a reason you didn't serve the Attorney General at that time when you raised the issue?
Yes, there is. I was unaware of the statutory of 272112.
Okay, so you didn't know about it. The city didn't know about it by their own admission. So then for some reason you found out about it and you immediately served the Attorney General, correct?
That's correct. When it came back from the Court of Appeals, and another motion for summary judgment was filed we never got to the constitutional issue, by the way. All these other issues got in the way, but yes, when it came back from reversed by the Court of Appeals, the city raised it for the first time in their motion for summary judgment. We saw that, looked the statute up, and responded, got in touch with the Attorney General's office, served them appropriately, 4.1, with a copy of the complaint. They wrote back and said they're not interested in participating. And
Counselor, what if they were interested in participating?
well, if they were, then I think they would then file an appearance with the court or a motion with the court to participate.
Well, but could they have the arguments that the city submits now?
I'm sorry, what was that?
If the Attorney General's office wanted to participate and then got notice later on, as opposed to the inception of the case, and they complained that they were not served at the inception, what would happen to the case?
Well, I think that the trial court has control over that situation. They could continue the hearings on the motion for summary judgment. They could allow the state, the Attorney General, to participate, to take discovery. They could do any number of things because they have the case.
But not dismiss the action, not dispose of the action.
I think if the Attorney General was heard and said that they wanted to participate or look into it, the trial court would grant them that opportunity. You know, as a practical matter, this was not a state statute that was at issue. It was a municipal ordinance. And I've looked at researched this a little bit, but the Attorney General rarely gets involved in these situations. And I suspect it's not all that interested in the constitutionality of a Cincinnati ordinance.
Doesn't this lead us back to Justice Donnelly's question about gamesmanship, where a person can wait to assert the constitutional claim and then serve the AG at a later point in time, and the AG is now under the gun? There's all these things that have happened, all these hearings that have taken place, all this discovery that's taken place. And now, well, you know what, at this late stage, we really just don't want to be involved. Doesn't that encourage gamesmanship?
I think the statute certainly allows the opportunity for gamesmanship. I'm not asserting here that the city has done that, but clearly the party could use that, and if they lose, then they could argue, well, there's no jurisdiction. I think the legislature should address this issue, and I think they should put in a definitive time limitation. They could say that the notice has to be served before a definitive motion is filed, or they could say that.
I thought you started off by saying the statute was unambiguous.
Yeah, I think it is unambiguous. I think what the court needs, what needs to be done is words need to be added, significant words, timing words. I don't think the lack of the timing makes it ambiguous. I think it just clearly says there is no time limitation, which I think is a problem, frankly.
If the service of process on the AG didn't occur at the first instance when it should have, would you then agree that there was a time period where the court did not have jurisdiction over this constitutional issue?
Well, if you read the statute, it makes this jurisdictional. I guess that would make the early rulings by the court, although they've been reversed, void maybe for not having jurisdiction.
Well, the reason I was asking you that is, it then seems if it's jurisdictional, and we somehow are able to skip past that jurisdiction not being raised when it should have been, and then we get into an analysis of prejudice, it seems like in every case we're going to go back retroactively and determine what was the level of prejudice as to whether or not the trial court did or didn't have jurisdiction. And in essence, doesn't that make the situation more messy than if we just follow the two Supreme Court cases that say it has to be when the constitutional issue is first raised? Isn't that our best precedent?
No, I don't believe so. I think that the legislature should speak to this issue. I don't think it's in the courts for the court to properly add a time limitation when the legislature clearly did not want to do so. It's a problem that they've created, and I think it's a problem that they should fix. I don't think it's up to this court to legislate and tell the legislature, you should have said that the service on the Attorney General should be within 30 days of the service of the complaint, or when the definitive motion is filed, or before discovery is commenced, I think you're changing the statute.
Well, I'm not trying to hijack your oral argument, but doesn't that take us back to Sitco and the previous Supreme Court case where the court said if the statute is ambiguous, we then try to look to what the intent of the legislature was, and the intent was at the commencement or when the issue was first raised. It's kind
I'm
of what
not
those
sure.
cases said.
Oh, I'm sorry, Your Honor. I didn't.
No, it's fine. I think that's kind of what those cases suggest.
Yeah, but I'm not sure that we know what the intent of the legislature is here. I think the intent of the legislature may have been to leave this up to the attorney generals and let the attorney general decide whether they've been prejudiced by a late, arguably quote unquote late filing.
Does that mean the attorney general gets to determine when the court exercises subject matter jurisdiction?
I think it gives the attorney general the opportunity when they shall be heard. It gives them an opportunity when they are heard to do any number of things. They can elect, like they did in this case, and say, we're not interested. They could jump in with both feet and say, this is vitally important to us and we want to participate. I think that's what the intent of the legislature was, is to leave this up to the attorney general. Maybe that wasn't such a great idea. I don't know. And maybe we wouldn't have done it that way. I don't think I would have, but that's what they did. And my point is, we followed the statute as it was written. And I think, and no one has shown prejudice by the timing of this. And certainly the city who blames us for waiting 2.5 years, they also waited 2.5 years. They could have raised it in a 12B1 motion. And so I think the legislature should amend this statute and put in a definitive time limit so that you don't end up with coming up here case by case basis trying to make sense out of the statute.
Well, it would not be necessary to do a case by case if we just say the statute, your case comports with Chico and it's at the inception. In other words, the beginning of the case.
Well, but I don't think that's the holding in Chico, Your Honor.
I know you don't, but if we modify or clarify Chico and say this is what was intended and this is now crystal clear based on the Cincinnati versus Fourth National case, and then you become the touchstone for all cases going forward with this problem.
Well, I don't think inception of the case, I think you need to be more definitive than just inception. I'm not sure what the inception of the case really is.
Well, we use more artful language than that, but that's the first thing that popped in my mind. Don't hold me to that.
Okay, well, I'm not holding you to anything, Your Honor. But my point is, as I raised earlier, is I think what this court should do is say that Fourth has followed this statute, and it is within the holding of not the dicta maybe, but the holding of Chico, and it's up to the legislature to come forth, and if they want a specific time limitation, then they ought to insert it in the statute. And that way it's definitive and everybody knows when to do it. Within
Thank you.
30.
Thank you, counsel.
I've used up my time. Thank you very much.
Yes, you have. Mr. Manning, you've used your time. You may take a minute.
I would just say, Your Honors, that we do know what the intent of the legislature is because this court said in Chico, both looking to the text and the purpose what it is. And so I just asked this court to reaffirm what it says in Chico and reverse the First District Court of Appeals.
Thank you. Thank you, gentlemen. We'll take the matter under advisement and you'll be notified of our decision.
Now I click out.
All right, our second case this morning is 2019-939, Menorah Park Center for Senior Living versus Irene Rolston. For the appellant, Mr. Lang.
Chief Justice O'Connor, may it please the court. My name is Brian Lang and I represent the appellant Menorah Park Center for Senior Living. At this time, I'd like to reserve 3 minutes for rebuttal. Menorah Park requests that this court overrule the 8th District Court of Appeals decision, which created new law and reinstate the dismissal of the class action counterclaim of the appellee. Menorah Park's proposition of law is premised generally on the fact that Hipaa specifically provides for the disclosure of protected health information for purposes of seeking payment, whereas there is no Ohio law addressing this issue. As such, Hipaa preempts Ohio law on the issue, and further, allowing the appellee to prosecute a claimed failure to comply with the rules of Hipaa would improperly allow the enforcement of a Hipaa provision in state court, which is contrary to longstanding Ohio law. The appellant Menorah Park is currently faced with the prospect of a class action counterclaim seeking over $3 million in damages as a result of seeking to collect approximately $400 in unpaid medical bills. In order to seek payment for these services, Menorah Park filed a small claims complaint with the Shaker Heights Municipal Court, attaching to the complaint 2 account statements representing unpaid bills consistent with Civil Rule 10. The 2 account statements attached to the small claims complaint include the name and address of the appellee, the dates of service, a 2 to 3 word description of the service rendered and procedure codes, as well as the amount charged, paid, and due. The account statement.
Mr. Lang,
Yes.
to interrupt you, were there any aspects of the attachment redacted?
There were no aspects of the attachment that were redacted, nor does Menorah Park believe needs to be under Ohio law.
Well, could there have been any aspects redacted that could also preserve the essence of your claim?
I don't believe anything could have been redacted and provide notice of the claim consistent with Civil Rule 10 and the notice provisions under Civil Rule 8. If the descriptions of the services and the dates of services were redacted and all that was there was an amount, what is the claim for? Is it for some business fee? Is it for a computer fee? Is it for a dining fee?
Well, it's interesting because if some of the private information had been redacted and then the defendant would ask for more definite statement, then the Civil Rule 10 would still be satisfied if you then submitted the unredacted statements. It's almost then as if the defendant would be inviting error or inviting this claim if there was some redaction and then there was a request that all the information be exposed.
If that occurred with the motion for a more definite statement and then that information was disclosed, certainly the defendant would have invited that. But it's Menorah Park's position that under the minimum necessary standard in Hipaa, that Menorah Park fully complied with that standard. And that standard was not meant as an impediment to payment. It's a flexible standard. And under certain circumstances, it would have required that all of the medical records be disclosed. Certainly if this case would have been litigated and the appellee challenged down the road these services, the appellant would have to present the actual medical records establishing that these services were provided and that they should obtain payment for them. With that said, the Barberton Court in the 9th District recognized that just the amount of the payment is not sufficient to put the defendant on notice of the claims against it. With all of that said,
well, why did the procedure codes need to be on there? I mean, you could have said medical services, you could have provided dates. It seems the procedure codes are what really allows someone to know what injuries or disease this person has.
it doesn't let them know what injuries or disease the person has.
They know what you can figure it out pretty easily. You can look up the procedure codes and figure out what treatment they're getting. I mean, that's
you can figure out what treatment they're getting. With that said, Your Honor, to do that and for Ohio courts to consider that, they would be interpreting the provisions of Hipaa. Basically, they would be looking at
you're not interpreting the provisions of Hipaa to look up what the procedure codes mean. You could find. I mean, I have a hard time with your argument that somehow this is preempted by HIPAA. HIPAA just says that you can't disclose certain things for federal purposes. It doesn't prevent the state from having a more restrictive body of law about what can be disclosed. I mean, just because something is a safe harbor within HIPAA doesn't mean that it's permissible under state law.
I agree with that, Your Honor. And the point here is that HIPAA does have a specific preemption provision, and it includes an exception, as you have stated, for state laws that are more stringent than HIPAA with respect to disclosure. There is no Ohio law that specifically deals with the disclosure of protected health information for purposes of seeking payment. There's no regulation, there's no statute. The appellee has relied on the Biddle case, which certainly did not address this specific issue.
Well, isn't that kind of more the issue here? I mean, it's really not a preemption case. I mean, isn't the question whether or not we should get rid of Biddle entirely? This is an area now that's extensively regulated by the federal government. Why aren't you arguing, as some of the amicus did, that this court should? There's no longer a need for Biddle.
I certainly do agree with that, Your Honor. I think there are 2 points here. I do believe that there is preemption here because I don't believe there is an Ohio law that's more stringent than HIPAA on this issue. I don't believe there's, the Biddle case basically provides for unauthorized and unprivileged disclosures, there is a claim, but it recognizes that there are statutes, regulations, and common law that provide for disclosures. And in this instance, there's a HIPAA provision that provides for a disclosure. There's no Ohio common law that's contrary to that. But to your point regarding Biddle,
there's no HIPAA provision. The HIPAA provision, what it does is says you're not liable under HIPAA if you do these kind of disclosures. It doesn't give you a right under state law to disclose those things. In fact, HIPAA makes clear the opposite.
Well, I believe HIPAA does provide the opportunity to disclose protected health information, even under state law. I don't think there's any state law.
Well, what HIPAA says is it's not a violation of HIPAA to do that. It doesn't say it's not a violation of state law to do that. I mean, HIPAA's, absolutely clear that you can have a more restrictive requirement under state law.
I agree with that. And as the appellee relied on a number of cases, there were more restrictive means in those other cases. For instance, there were 2 cases involving ex parte communications with treating physicians, and there were specific state laws that dealt with those communications, and the courts in those cases looked at whether the state law was more stringent than HIPAA, and if it was, then the state law wasn't preempted. I don't see a state provision here dealing with disclosure of protected health information, and that there is no more stringent. With that said, going back to your original point regarding the Biddle case, I agree with Your Honor. I don't know that there is a reason for Biddle to still remain given all of the protections that are set forth in HIPAA. The Hipaa rules protect privacy and security of protected health information while affording covered entities the ability to use and disclose that information in a fair and logical system. The Biddle case doesn't get into the intricacies that HIPAA does, and obviously Biddle was decided before HIPAA. HIPAA has numerous protections for patients, including the ability to file a complaint with the Department of Health and Human Services, with patients filing over 200,000 complaints, and Health and Human Services implementing over $100 million in fines against covered entities. The penalties go up to $50,000 per instance. And in addition, HIPAA allows state attorney generals on behalf of residents of their states to obtain damages for those residents. So even under HIPAA, the patients can still obtain damages in addition to the statutory penalties that are present. And in light of those considerations, Your Honor, I agree with you. I'm not sure that Biddle should still be present. Under that Biddle test, it's very vague. It's somewhat unworkable. It talks about a countervailing interest, and because of that, all of these cases would need to be litigated and potentially resulting in disparate results, both in Ohio and across the country, in determining whether the disclosure was the minimum necessary. Certainly, and there are health systems that go across the country, and there may be one ruling in state courts that's inconsistent with a ruling in another state court. Hipaa has specific provisions that deal with all of these issues. And with the implementation of Hipaa, they specifically recognize the importance to these medical and health providers to have the ability to collect and seek payment. And that's why they allowed for the disclosure under those circumstances and set forth this minimum necessary standard. And with that, it should be left to the Department of Health and Human Services, not a state court and a jury, to determine whether that standard was met. So I agree. The question as to whether Rebuttal should still remain with the implementation of Hipaa, I'm not sure that it should, Your Honor. I think Hipaa does cover this area. It's very detailed. It has evolved over time with the implementation of the electronic health record, which has come into effect over the past 10 years. Hipaa has now added the HITECH Act to address that. The Rebuttal case doesn't address all of these intricacies. And in essence, courts would need to look at each specific issue depending on what kind of disclosure might occur to determine whether or not it would violate the Rebuttal standard. I think that's better left to the Department of Health and Human Services to analyze that and make the determination. The Department of Health and Human Services recognizes and is flexible, recognizes that these entities need to have the ability to seek payment and not be faced with concerns regarding potential class action counterclaims and the extensive cost of filing complaints by hiring attorneys and filing things under seal. These entities would not collect insignificant amounts such as the amount set forth herein if they were placed with the rules set forth by the appellee herein, and rather they would forego that. And that would result in an increase in the cost of medical services because that money would have to be regained somewhere. So I agree. I don't think that Rebuttal necessarily should still have a part. Also,
can we do that in this case, or is it properly forced? Would we need to ask for additional briefing?
No, I think you can do that in this case. I think the amici have addressed it, and I think that the question of whether Rebuttal applies to this case, it might be separate and apart from whether Rebuttal should remain, but I think the court can make that decision herein. Although it is Menorah Park's position, even if Rebuttal does remain, that it is preempted here. And further, to enforce this case, the court would need to consider Hipaa and the minimum necessary standard, which would be contrary to longstanding law that state courts should not consider that standard, and it's not setting for the private right of action. And Your Honor, I'd like to reserve my remaining time for rebuttal unless you have another question.
Thank you. Mr. Flowers.
Good morning, Chief Justice O'Connor, Associate Justices. May it please the court. My name is Paul Flowers. I represent the defendant appellee in this case, Irene Rolston. After listening to counsel's argument, I'm more convinced than ever that the sole objective of this appeal is to allow debt collectors to disclose private and confidential health information in lawsuits that are publicly filed against patients who are unable to pay their bills. The simple solution is for them just to redact the descriptions of the treatment, which is what we see in the Ohio Health case that was the basis of their motion to dismiss. That court found that there was no violation, there's no Rebuttal claim because the information was redacted, because the disclosure was authorized, and that's all they need to do. But for reasons that are pretty clear to me now, they don't want to do that. They want that information out there in those complaints. I thought I'd start off with Justice Stewart's questions about the redaction. We see redactions all the time. Virtually every complaint for medical bills is redacts the information. They redact the codes, they redact the descriptions. They usually don't even provide the dates. They might provide the amounts paid, and that's it.
And does that satisfy Civil Rule 10?
Yes, it does, because Civil Rule 10 isn't absolute. It says that you're to provide the document unless you provide a reason in your complaint for why you're not providing it. And so,
but does Civil Rule 10 require that?
Does not. It requires the instrument to be attached unless there's an exception. And then you're supposed to state in the complaint why there's an exception, and that's routinely followed. So in fee disputes, when an attorney is suing for fees, they never attach a complete itemized billing statement. They might attach a summary, or if they do attach a billing statement, it's heavily redacted. And in commercial cases where they're about contracts that contain sensitive information, such as pricing and relationships and so forth, they either don't provide the contract, or they state in the complaint that they're not providing it because it contains sensitive information, or they'll provide a redacted copy, or they'll file it under seal. There's lots of options here.
Well, couldn't your client in this case, or defendants in similar cases, simply ask that the private information and sensitive information not needed to adjudicate the claim be redacted?
Correct. Absolutely. And they did in this case. A letter was written early on, as soon as the complaint was filed, by defense counsel saying, hey, you just disclose all this information. And they didn't amend. They didn't change it. They left it on there. And they're fighting tooth and nail to keep it on there and to retain their right to disclose health information in these debt collection complaints.
Mr. Flowers, I think I heard counsel for Menorah say that when you have such as this, which I believe was in Shaker Heights, municipal court, that it would be too burdensome for it. I think I heard that was one of the things that was offered as a reason for that it's not practical, that it's too burdensome. And besides, they're using codes, and you'd have to go to some lengths to determine what those codes actually revealed.
Right. That's just specious. I mean, these exhibits are redacted all the time in legal cases, medical cases, all sorts of collection cases, all sorts of contract dispute cases. There's heavy redactions and explanations for why. Regularly, all it takes is a pen and a black marker and just going through it item by item. And the codes are not that hard to figure out. All you have to do is go online. The code access sheets are available. You pull them up. You can find out immediately what somebody went through. And here, this exhibit says that this woman went under a specific kind of treatment. I mean, it does not take any sort of medical knowledge to figure out from what they left on there what she went through. And maybe hers isn't so sensitive, but at Menorah Park, you're going to have people with dementia, incontinence, all sorts of medical issues that they don't want disclosed. Yet Menorah Park makes it very clear that, hey, if we need to sue you for a bill, we intend to include all this information because we've got this kind of preemption conflict issue and whatnot, and that's our right. This court should not go down that road. I mean, Rebuttal is no aberration. Rebuttal is founded on decades of law in Ohio and elsewhere. In her concurring and dissenting opinion, Justice Cook points out that Rebuttal is not new, that it is based on prior law. So if this court were to overturn Rebuttal, a lot of precedents would have to be overturned. And then Ohio would stand alone, as far as I can tell, as the only state that does not allow private remedy for disclosure of private health information. I know of no other state that has done this. There are lots of states that have Rebuttal type remedies. I mean, Rebuttal was founded.
Yeah, Mr. Flowers,
Justice French.
could you have had did you have the opportunity to file a HIPAA complaint?
No. If you look at Ohio Health answers that. It says that even if there was a remedy under the HIPAA, it's not the plaintiff's remedy. Only the Department of Health and Human Services or the state attorney generals can invoke it.
I guess I appreciate that. Let me be clearer. Could you have filed a request? Could you have filed something with the department that says this is a violation? Could you have notified the government of a potential violation?
Yeah, sure. And who knows where it would go. There's no guarantee of any relief. It's significant that they're not raising a failure to exhaust administrative remedies here. I mean, they've never argued that, particularly in their motion to dismiss, because there is no practical effective remedy for the patient whose information has been disclosed. Best case scenario is that, the provider who discloses this gets a fine, maybe that's it. But there's no indication that the Department of Health and Human Services and the attorney generals have the resources to monitor these tens of thousands of collection cases that are being filed across the United States and respond when private information is disclosed. I'm sure that's one of the motivating factors for Rebuttal, as has been adopted throughout the United States. that, these people whose privacy is violated need a remedy. It's just a basic privacy remedy situation. Nothing new. And remember, Biddle doesn't stand by itself. Biddle was affirmed in Hageman. I mean, in Chief Justice Moyer's opinion, they embraced Biddle. And according to Chief Justice O'Donnell's dissent, Hageman expands on Biddle, taking it even further. So this is something that is well established in Ohio precedent. Wiping it away might be great for debt collectors, but it would take unearthing decades of case law and leaving Ohio by itself in this world as far as a remedy being provided. This whole action, the motion to dismiss, was originally based on Ohio Health versus Ryan. They're not talking about that now. I mean, Ohio Health found consistently that there is no preemption, that we had a situation where the records were redacted, which refutes this idea they can't do it. And because of that, there was a dismissal on the pleadings. And then we have the same findings in Sheldon. And the Sheldon court is very clear that there is no preemption. Despite all the arguments that were made, there's no preemption. And what the second district wrote in Sheldon is right on point with Justice DeWine's comments earlier in paragraph 25. We determined that a Biddle claim is not preempted because we failed to see how such a claim conflicts with Hipaa unless the alleged claim asserts recovery for release of information that Hipaa specifically allows.
Mr. Flower, what about Mr. Lang's statement that should this court rule in your favor, then it subjects his clients and multiple parties like them trying to recoup and recover costs for medical services, subjects them to millions of dollars in class action lawsuits?
No, I mean, that's really far-fetched. I mean, how many of these lawsuits have we seen? Everybody is redacting. They all redact. They even sometimes don't even submit billing statements. They just do a summary with the total on it.
Isn't that in violation of Civil Rule 10?
No, again, Civil Rule 10 routinely is utilized in the context of privileged and sensitive information that's in these exhibits because Civil Rule 10 allows you to state that I'm not providing it for this reason in your complaint. It's not absolute. So, I mean, if he's right about that, then all these hospitals, all these lawyers, everybody else who's redacting information is violating Civil Rule 10.
But does Civil Rule 10 require Mr. Lang or require his client to do that?
Now, again, it's not absolute. I mean, it specifically says if you put in your complaint the reason you're not providing the document,
right, but it doesn't require them to redact.
No,
So,
the requirement to redact is in the privacy laws. I mean, just like, any other complaint, bills for legal services, incidents where you've got privileged information, attorney-client privilege perhaps, anything like that, the plaintiffs are all either redacting or not even providing the instrument entirely with an explanation of why. Now, just to follow up on your question earlier, suppose the plaintiff then files a motion for more definite statement and says, hey, you didn't include this. Well, then they've waived it. Then the plaintiff has every right to put it out there. But we don't have that here. We have the opposite, where the patient's lawyer came right out of the gate and said, hey, you're disclosing information, and they did nothing. They did nothing to try to file that under seal, to conceal it, to amend it, nothing. They are here today insisting that everything they did was right, and they can disclose what they want because the patient won't pay their bill. And that's just not a road that this court should go down. It's completely contrary to Ohio precedent and precedent across the country.
So I wonder if we could go back to Ohio Health and your reading of Ohio Health. As I look at Ohio Health, it seems to me what the court was saying was, the question is whether there was an unauthorized disclosure. And you look at other sources to decide, is this unauthorized? And one of the sources that you look to is Hipaa. And because Hipaa specifically authorizes the use of medical information for purposes of collection, this is not an unauthorized disclosure. So I think, are we reading Ohio Health differently? That seems to me to work in Mr. Lang's favor here. If the question is it unauthorized, and we say no, it's not under Hipaa, does that end the matter?
But I was in full agreement with you right up to that last part about supporting
I
Mr.
thought
Lang.
you would be, so tell me why.
I mean, I think Ohio Health, like Sheldon, fully supports our position because, in Ohio Health, the issue is it authorized? And, if it is under any law, not just HIPAA, if it's authorized under any law, paragraph 2 of the syllabus of Biddle says there's no claim, so there's never any preemption because there's never any conflict. Biddle excludes that. And just to point out, I'm getting your answer in a minute, to point out, the HIPAA was enacted in 1996. Biddle came out in 1999. So HIPAA was there first. The current regulations, sure, they came afterwards, but the Biddle court, I'm sure, was well aware of HIPAA at the time this was enacted, and the Hageman court certainly was aware of HIPAA because they cited it. Just to get back to your question, yeah, that's the nub of it. That's what this case is about. If it's authorized, they win. If it's not authorized, we lose. And it's spelled out in their reply brief, which I fully agree with. This is on page 10. If a jury determines Menorah Park took reasonable efforts to limit disclosure to minimum necessary within the meaning of CFR 164.502B, then the disclosure would have been authorized by federal regulations and any contrary state common law claim would be preempted. Moreover, if disclosure is found to have been authorized, then it would not have been unauthorized disclosure required under Ohio common law in Biddle. That's exactly right. I mean, that's the nub of it. And you can't decide that in a 12B6 motion. Whether they did the minimum necessary as the regulations require is an issue that has to be determined in this case. And they're not going to win that because they did nothing.
Right, but aren't we right back to preemption then? If
Now,
what we're really talking about is compliance with HIPAA, why isn't that a HIPAA question and it's preempted?
It's not preemption because it's the cart before the horse. I mean, Biddle says if you comply with any law, that's privileged. That's paragraph 2 of Biddle. So HIPAA, any state law, anything, if they can show that they're complying with that, then there's no Biddle claim. It's a defense. So you don't get any preemption. And that's what the Sheldon court said is, we don't see how this conflicts, because you're never going to interfere with HIPAA because HIPAA is a defense. Just like any other state law that permits disclosure, and there's a lot of them, are defenses as well. So that is why there is no court that has held that these types of Biddle claims are preempted by federal law. In fact, the 8th District in their decision, they cite a laundry list of out-of-state cases all holding that there's no preemption, and there's no serious argument with any of them. I mean, this court is being urged to break new ground in this country for the sole purpose of just allowing confidential health information to be disclosed in complaints that are filed against patients. So I see my time is winding down. With that, I would thank everyone and ask you to affirm the 8th District Court of Appeals.
Thank you. Mr. Lang, you have a little over 2 minutes. You have to turn your microphone on to use them.
I apologize, Your Honor. Thank you. First, I would like to address the Ohio Health decision because I don't understand Mr. Flowers' representation of this case. In paragraph 17 of Ohio Health, it specifically states, here, however, we are aware of no applicable exceptions to preemption, and because HIPAA is applicable to these circumstances, HIPAA is the governing authority. Therefore, because appellant has failed to cite to any Ohio authority which is contrary to HIPAA regarding the disclosure of protected health information for purposes of payment for medical services, and which meets an exception to the federal regulation, appellant's claim is governed by HIPAA. Ohio Health stands for the proposition that HIPAA preempts state law with respect to this specific issue. It's not Menorah Park's argument that HIPAA preempts all potential causes of action for disclosure of protected health information. But
Mr. Flowers says that his client requested that the complaint be refiled and the information be redacted. What was the problem with complying with that request?
Your Honor, I'm not aware of that. That's not part of the record, and I was not representing Menorah Park at the time the small claims complaint was filed. With that said, getting back, also addressing the ICD-9 codes, those codes aren't protected health information. It simply reflects the services that were provided to the individual. I'll also address the Sheldon case.
But Counsel, let's talk about those codes. They're pretty telling, are they not? if you have the key to review those codes, you know what the health issues are.
You don't know what the health issues are. You know what services were provided. At the same time, if we attach an account statement that only includes the amount of money that is owed, the plaintiff is put on no notice of the services that were provided for which payment is being sought. But Menorah Park was simply
But that information could have been submitted under seal, correct?
Your Honor, it could have been submitted under seal, but if medical institutions are required to submit documents under seal and file claims with attorneys for these small amounts of money, $400, $500, $1,000, they're just not going to do it. They're going to forego the ability.
I don't know that I can accept that this is not economically feasible for the plaintiff here in the collection actions. So we can violate, the private information, health information. I don't know that that's a justification here.
Well, the supposed violation here is a violation of Hipaa, Your Honor. It's the minimum necessary standard, which, as recognized by Ohio Health, should be enforced by the Department of Health and Human Services. If, in fact, there's a violation here, I believe that a question was asked earlier. Certainly, there's the opportunity to file a complaint with Health and Human Services. Certainly, there's the opportunity to contact your Attorney General and ask them to pursue a complaint on your behalf in which you can actually receive damages. But the point remains, there is no more stringent law in Ohio with respect to the minimum necessary standards set forth in Hipaa for purposes of disclosure for payment. And because there's no more stringent law, Hipaa governs. And to allow the appellee to proceed in a case and basically have a trier of fact determine this minimum necessary standard would be contrary to the law, which says you can't enforce Hipaa in the state action.
Thank you.
Your Honor, thank you.
Take the matter under advisement. You'll be notified of our decision. Our third case this morning is 2019-1433 in the state of Ohio X-Rail Cable News Network Incorporated et al. Versus Bellbrook-Sugarcreek Local Schools. For the appellant, we have two. First, we will have Ms. Reinhardt.
May it please the court. Chief Justice O'Connor, Justices of the Supreme Court of Ohio. My name is Erin Reinhardt, and I represent the media appellants in this case. I'll be splitting my time with Mr. Benjamin Flowers, who is arguing on behalf of the Ohio Attorney General. I will argue for 10 minutes, Mr. Flowers will argue for 5, and I would like to reserve 2 of my 10 minutes for rebuttal. Your Honors, appellants ask this court to reverse the 2nd District Court of Appeals decision and find that neither the Family Educational Rights and Privacy Act nor its state counterpart, the Ohio Student Privacy Act, prohibit disclosure of the education records of a deceased adult. Overwhelming authority from this court, the United States Department of Education, and other states presented with this issue consistently find that when an adult student dies, the confidentiality protections of these statutes are no longer applicable. There is no reason for Ohio to be an outlier here.
Counsel?
Yes.
What do we do with Revised Code 3319.321B, the last section, or without the written consent of each student who's 18 years of age or older? Seems pretty clear.
The statute should be interpreted consistently with FERPA. The FERPA statute has been consistently interpreted to find, with the exact same language, that upon death, an adult student no longer has those rights and can no longer provide consent. Therefore, there's 3 options here. 1, a student who dies is impossible to provide consent. 2, there's the interpretation where the court rewrites the statute and provides that someone else should be providing the consent, such as an administrator or executor, which is improper under this court's precedent. Or 3rd, the court rules in favor of the appellants and finds that where the statute is silent, it defers to the agency's excuse me, the agency's guidance. It's similar to what the court did in Souffrance v. Doe, where the court was interpreting whether or not FERPA and the Ohio Student Privacy Act applied to former students. In that case, the court deferred to the Department of Education, as well as the sister state's analysis of the issue, and applied the same exact statute and subsection of the statute at issue here today, consistently with FERPA.
Wouldn't that undercut the sunset provision of 75 years?
No, Your Honor, it does not. The sunset provision is only applicable where an exception is applicable. So if these exceptions are not applicable, the sunset provision does not even kick in. Your Honors, for decades, this court has interpreted Ohio's Public Records Act liberally and in favor of broad access to records. Here, the parties have stipulated to all the relevant evidence. There is no dispute that appellants are a public officer and public office, and that the requested documents are records under the revised code. Therefore, unless the appellees, as custodians of the records, can establish that an exception is applicable, the records must be disclosed. To justify their withholding of the records, appellees rely solely on the confidentiality provisions afforded under FERPA and the OSPA. Therefore, the sole issue before this court is whether either statute prohibits the release of a deceased adult's education records. As shown in the briefing, the answer is no. The fundamental rules of statutory construction apply here. The parties agree that both statutes are silent on the specific issue before the court. Therefore, the court must consider the intent of the legislature. The intent of the legislature is made clear when three things are considered. First, the common law against which both statutes were enacted, which refuses to extend privacy rights to the deceased. Second, consistent guidance from the Department of Education regarding FERPA's inapplicability to deceased adult students, as well as precedent from other states that have found that agency guidance to be applicable and have consistently applied it to both the federal statute as well as their state analogs. And third, this court's prior finding that enactment of the OSPA was to bring Ohio into compliance with FERPA. In School Choice Ohio, this court found that FERPA was enacted to protect the privacy rights of students. The OSPA was enacted to bring Ohio into compliance with FERPA. To Judge Fisher's question, there is no reason to interpret these statutes differently. They are exactly the same for purposes of this issue. The common law against which both of these statutes was enacted also finds that privacy rights lapse at death. In Cordell, Young, and Reeves, the Sixth Circuit Court of Appeals found that Ohio law is consistent with the, quote, general rule, end quote, that the right of privacy lapses at death. In other words, the default here is inapplicability post-mortem. In 1996, this court agreed. In Finley Publishing versus Schroeder, the court ordered the disclosure of the records relating to suicide victims and refused to find that the deceased had privacy rights that would prevent disclosure of those records. Second, the Department of Education, as mentioned previously, has consistently interpreted FERPA's confidentiality protections to terminate at death. This court has followed the Department of Education's guidance when interpreting both FERPA and the OSPA. Again, as I mentioned in Souffrance, the court evaluated whether FERPA applied to former students. In rendering its decision, the court relied on the guidance of the Department of Education to interpret both FERPA and the parallel provision of the Ohio Student Privacy Act.
So I wonder if we could delve a little bit more into FERPA then. Is it, I mean, I'm a little troubled by the idea that we as the Ohio Supreme Court have to look at just how FERPA has been interpreted and what the FERPA federal guidance has been. I mean, what's the extent, do you think, of the ability for the state of Ohio to determine for itself when the confidentiality would end? Is there no ability for the state to do something different than what the federal government has done?
No, there is. There absolutely is that ability. However, the legislature, Ohio's legislature, the General Assembly chose in this case to use the same language as was used in the federal statute.
But even if we give you that, that the language is the same, why does that necessarily mean that the interpretation has to be the same?
Because any other interpretation of the statute would be either absurd, requiring the consent of a deceased individual, which is impossible, or it would be rewriting the statute altogether by providing that someone else, aside from the decedent, should be permitted to provide that consent. There is no consistent legislative approach in Ohio or at the federal level when it comes to determining the confidentiality protections of a deceased individual. So for example,
I'm having a hard time understanding your argument that we would have to rewrite the statute to allow someone else to provide the consent. Why wouldn't we just apply the statute, do exactly what it says? No person shall release without the written consent. If there's not written consent, no person shall release. That seems completely straightforward.
Because there's absolutely no legal precedent to support
Well, what about the statute? What about the plain language of the statute itself? I mean, if I gave this statute to my 15-year-old kid, he could understand exactly what it says. Why wouldn't we just apply that language?
Well, the statute is silent on the express issue before the court. And under this court's
It's not silent. It says no person shall release. That's the issue before the court is whether or not someone shall release. It says no person shall release.
The statute actually says
it doesn't deal with a hypothetical situation that someone else may present, but you don't have to add or subtract words to the statute to apply it.
The statute actually uses the word student, and both of them, the federal and the state analog, use the word student and requires the student consent. It is silent, and the parties don't dispute that the statute's silent on whether or not that student, once deceased, has any rights or anyone else has any right to provide consent. The legislature does not have a consistent approach. And in fact, where it's silent under Lang versus Department of Job and Family Services, the court should defer to agency guidance where applicable. So there is longstanding precedent from this court that shows that where a statute is silent, it should probe beyond the plain language of the statute.
Well, Counselor, couldn't a student have provided consent before passing away? The student at issue in this case, arguably, he could have consented to his records being released sometime before his demise, correct?
The consent would have to be done at the time of the request. Otherwise, it doesn't allow the student to change their mind.
But the student could have given consent prior to, so are you saying the statute prohibits consent prior to request?
No, not at all, Your Honor. What I'm suggesting is that the student must provide consent at the time that their records are asked to be released.
But you're saying there's no prohibition to there being some form of consent on record prior to a request.
Correct, but the statute does not read that way. The statute provides that the student must provide consent. Where the student, in this case, is now deceased and it's impossible to provide consent, there is no other applicable.
Counsel, what about approaching it through the probate? If there were a executor or an administrator appointed, would they be able to consent?
No, Your Honor, they would not. If the court were to find that the executor or administrator or some other person were able to provide that consent, the court would essentially be rewriting the statute.
Well, that means if that's your interpretation, that the duly authorized administrator or executor, which has broad duties and responsibilities and rights once they're appointed by the court, even that type of entity could not disclose, then it seems to me that the legislature was pretty, they truly meant what is written here. Nobody can do this.
No, Your Honor, the other statutes that have been cited by the appellee show that there's no consistent approach. Some of them are silent, similar to here, and the other statutes either provide for a specific period of time or provide for a specific individual that may provide that consent. Some of them provide for the rights of an administrator.
So then the statute, the writers of the statute knew what they were doing in these instances and made specific, included specific language to establish what their intent was.
In certain statutes, they did. In other statutes, they left it silent, like here. And in that case,
intentional. What would presume to be intentional?
Well, under the Lang decision, if the statute's silent on the express issue, then the agency deference should be afforded. Your Honors, I see that my time is running out. I'd like to defer the balance of my time to Mr. Flowers.
Mr. Flowers?
As Chief Justice, and may it please the court, I'm here on behalf of Attorney General Dave Yost. I'll quickly run through our argument here. I want to explain why we're here and then why the statutory text and purpose support the position we're taking. So the initial matter, why are we here? We're fortunate to live in a country where the government works for the governed and not the other way around. And because of that, to maintain that balance, this state has long appreciated the importance of maintaining public access to government records. The records in this case serve an incredibly important purpose because they may hold clues the public can use to educate itself and its legislators about the red flags raised by mass shooters and potentially to hold accountable local officials who failed to heed those warning signs. So that's why we're here. Of course, we also want to get law right. So why do we think the law supports the position we're taking, which is that disclosure is required? If we look at the text of both FERPA and the Ohio Student Privacy Act, both create a privacy right. They don't create a complete bar on disclosure, but they rather allow disclosure with consent. The reason that matters is because, or rather, given that it creates a privacy right, we look to the manner in which privacy rights were understood at the time. And at the time, and even today, privacy rights were understood to lapse with death. So to Justice Fisher, Justice DeWine, Justice French, I think Justice Stewart and Chief Justice O'Connor too, I think everybody, the question was, how does that matter here? What do we do with the text? We're not asking you to read an exception into the text. What we're trying to do is define the nature of the contours of the right that's conferred by the statute. So think of what the US Supreme Court did in the Heller case. In interpreting the Second Amendment, which dealt with the right to keep and bear arms, the court said, we define what that right is, what it consists of by looking to the legal history that led to its ratification. Look at what this court did in the 2010 case of Squire Sanders, where there was a statutory codification of the attorney-client privilege. And this court said, well, in incorporating that into the statutory law, we presume they took the common law meaning with it. So we're not asking you to make up an exception. What we're asking you to do is recognize this creates a privacy right, and the nature of privacy rights at the time these acts were enacted were that they lapsed with death. Nothing in here contradicts that. And so this is presumed to retain that meaning. I mentioned also the statutory purpose. Let's look at that. Once a student becomes an adult, he or she alone has the power to grant or withhold consent to the disclosure of records. The reason that matters is it suggests that the only purpose the statutes serve once the student becomes an adult is to protect the student's privacy, not his family's, not anyone else's, the student's. And so when the student dies, obviously he no longer has that interest, and that's why the disclosure is important. If I can make two more brief points, I'll try to squeeze them in. First, my friend on the other side points to an Attorney General opinion from 1990 that they say is inconsistent with the position we've taken here today. I have two responses to that. First, if there's an inconsistency, we were wrong then and we're right today. Second, there is no inconsistency because in that case, or that opinion rather, what the Attorney General recognized is that in interpreting when confidentiality obligations lapse, you have to look to the text. Here, for the reasons we just gave, the text suggests it lapses with death. Finally, I just want to emphasize this is the very sort of case for which the Public Records Act exists. It's so that individuals can obtain important information from their government that they can use to insist on legislation and potentially hold local and government officials accountable. I'm happy to answer any other questions, and we appreciate your having us today. If there are none, we ask that you reverse the second district.
Mr. Flowers, can I just ask you very quickly, do you have any problem with the fact that if the young man at issue in this case, had he gone to private school, this case wouldn't be here? So that public schools, students who are in public schools, if we were to rule in this case the way you want us to rule, students in public schools would be more vulnerable to the disclosure of their information than students in private schools.
A couple responses. In initial matter, I'm not positive that's true. FERPA applies to anyone who takes federal funding. So if a private school were to take it, they would be bound by that. Okay. I'm not sure the Ohio Student Privacy Act is limited to public schools, but if that is a problem, and I would consent, we don't want that sort of imbalance, there's a legislative solution, which is the legislature can respond by creating a similar rule applicable.
Counsel, isn't there a legislative solution here by the legislature merely stating what you're proffering, that death will allow for disclosure?
Certainly, and they could have done it that way. And frankly, I wish they would have done it that way and we wouldn't be here. But there are many ways to write the statute. And one, the task before this court is to figure out what this statute means. And as written, as the uniform guidance from attorneys general around the country and the Department of Education recognize, is that the default rule is that privacy interests lapse at death. These statutes create a privacy interest, and that may be why the General Assembly did not expressly account for that.
Thank you.
Thank you.
Justice.
Good morning, Chief Justice O'Connor. May it please this honorable court, counsel for the news media, counsel for the Attorney General's office. My name is Tabitha Justice. Today, I have the great honor and privilege of representing the Bellbrook-Sugarcreek Local School District Board of Education and Superintendent Dr. Douglas Kozad. The well-reasoned decision of the Second District Court of Appeals should be affirmed because federal and state law prohibit school districts from producing educational records without consent. The news media has presented a rational argument in this case why the statutory protections afforded educational records should potentially expire upon the death of a student. But that argument is best presented to the legislative branch for consideration, not this court. Neither FERPA nor the OSPA expressly grant a school district permission to release education records in these circumstances. Nor does either statute say that the protections afforded education records expire upon the death of the student. As when dealing with protections afforded by Hipaa, the attorney-client privilege, or other statutory confidentiality requirements, a public entity such as a school district must take the responsible course of action when faced with public records requests seeking confidential records. If the school district had unlawfully produced confidential records, that bell could not be unrung. Failure to maintain confidentiality of student records has consequences, including a breach of the public trust. If, on the other hand, this court concludes—
Counsel, if the student is deceased, what standing do they have to complain if it's released?
Potentially, the estate of the student has the potential to complain, but that's really not the issue here. The issue here is that the statute requires us to maintain the integrity and confidentiality of those records. FERPA actually withdraws funding, federal funding from schools that breach that statute.
Generally, invasions of privacy die with the person involved, correct?
The tort invasion of privacy would potentially, and it, as the Second District pointed out, that is not entirely well settled in Ohio. Publicity rights, for instance, and in this case may very well trigger such rights, do not necessarily die. Any statutory rights that an individual might have might not necessarily die. But again, the issue here, even if the family doesn't have a cause of action, the issue here is that the General Assembly has told school districts that they must maintain the confidentiality of school records, regardless of what a student may or may not be able to sue the school district for later if we breach it. And again, as I mentioned, FERPA actually withdraws funding from schools for the breach of those statutes. Now, ultimately, if this court concludes that the record should be produced, the school district will have clear guidance and instruction going forward, and it will be able to produce the records to the news media within a reasonable time. But the reality is that schools in the 600 plus school districts throughout the state of Ohio have been instructed for decades that both federal and state law require them to maintain the integrity and confidentiality of student records. The news media ask you to add to those laws. They said that they don't, but through the guise of statutory interpretation, that the protections afforded by those statutes expire upon the death of the student. But historically, this court has been reluctant to add words to a statute where the General Assembly has not done so. The fact that the statute, either FERPA or the OSPA, does not include an expiration date doesn't make it ambiguous. A statute is only ambiguous where the specific words used yield more than one reasonable interpretation. The news media and the Attorney General has not pointed to any ambiguous words in the OSPA. or FERPA for that matter. Adding words to a statute that is not ambiguous disregards the legislature's intent. When a statute is silent on a question, this court should not find it to be ambiguous and use the rules of statutory interpretation, even the legislature intentionally or even inadvertently omitted, even if they made a mistake and should have added that language in this particular statute. This court should not do so. That should be left to the legislature. No one disputes the Attorney General's position here that Public Records Act serves an important purpose. Open government is an important policy. The public should see what the government is doing. However, in fulfilling its function, the government collects significant private data about citizens. They have our social security numbers, tax records, driving records, and yes, our school records, among others. For the government to continue to function as it does, the public must have a certain level of confidence that the private information collected about themselves and their children will be protected.
So what kind of records are we talking about here? If not necessarily about this student, but just in general, what would be collected about a student?
And so I appreciate that question. Thank you, Justice French. The reality is, I think a lot of people think that school records are just attendance and grades, but they're not. School records are not just grades and attendance. Many school records contain information also protected by Hipaa. The guidance counselor privilege notes for guidance counselors have notes. The Individuals with Disabilities Education Act, which is the IDEA, special education records. I mean, I've seen special education records, and I'm using my hands, which is more easy to do in person than it is on video. But I've seen records where the very voluminous records for a single student. Often these records will include things like information contained in child abuse reporting statutes. We're talking typically when a parent makes a request for educational records, we even have to pull all of the emails that the parents and teachers exchange regarding that student, or even that the teachers exchange regarding that child. If you look at the statute 3319.321, it actually defines it as any personally identifiable information about that student can constitute an educational record. So again, we're not talking about just their grades or their progress. There's a lot of stuff in there that school districts collect about children.
You didn't mention disciplinary records, and I'm presuming that that's the crux of what this is all about. Given what is known about this at the time, this student or this adult at the time he committed his crimes, and then thereafter, and the disciplinary records and probably the guidance counselors, etc. That's really what they're looking for, correct?
I do believe that that's probably the case. Obviously, I can't speak on behalf of the news media and what they're actually looking for. But I do think in this particular case, when they make a request for the educational records of the student, they're wanting to see what the student was disciplined for in the past. But the reality is any counseling or mental health services or things of that nature that he received. Again, part of that could even be covered by the guidance counselor privilege, which is revised code 2317.02. Part of that could even be included in the Individuals with Disabilities Education Act, the IDEA. And so I do think that their focus is on the disciplinary records for this particular kid. But the reality is that when someone makes a request for educational records, we don't just look for one specific thing. And so, and they didn't necessarily limit it to just disciplinary records. In fact, it's not unusual for the school districts to get requests from the news media for educational records of kids that have been killed in car accidents, students who have committed suicide, and other students that have been tragically killed in some fashion or another. But it's also not unusual for school districts to deny those requests on the basis of FERPA and the OSPA. The news media has chosen this particular case in which to challenge those protections due to the especially compelling optics of a deceased student who's also a mass murderer. But decisions like this can't be based upon a single incident or a single awful person. Decisions about when a statutory protection should expire are best left to the legislature, which can consider the needs of all current students and, frankly, the rights of all of us here today to our own educational records. Now, I'd like to address the notion that the news media's position that unless a privacy statute expressly states that it applies after death, it expires upon death. I think first, such a rule has a remarkably broad implication on a myriad of such statutes, some referenced in 149.43 and some not. But moreover, if that were the case, it would render essentially the last paragraph of Revised Code section 149.43A1 largely meaningless. That provision expressly provides for an expiration date for confidentiality statutes that don't include their own expiration date. That statute assumes there are some privacy and confidentiality statutes, like the OSPA, that extend indefinitely, and it places a 75-year time limit for all such statutes. Finally, from a public policy perspective, the news media and the Attorney General, as you just heard, presents this case as if it's their goal to help the public to expose some weakness in the educational system or to expose what led a bad person to do bad things. But law enforcement, including the FBI, have access to materials through subpoenas and other exceptions to FERPA. The Attorney General's office, the Governor's office, and even this court could access those records if access met one of the exceptions. But the reality is the legislature has not made an exception solely for the death of a student. Maybe the facts of this particular case will change how they look at this, and maybe they will go in and reconsider some of the exceptions or even add an exception for these exact circumstances. But at this time, Congress and the Ohio General Assembly have carefully crafted statutes to protect the confidentiality of education records. Both have shown that they are capable of drafting expiration dates for those statutes based upon death or the passage of time. This court should not imply an expiration date where none otherwise exists. And again, from our perspective, the judgment of the Second District Court of Appeals should be affirmed. Thank you very much for your time. I'm happy to answer any additional questions in my 3 minutes and 24 seconds if there are any others.
Thank you.
Thank you.
Your Honor, if I may, for rebuttal, I have 2 points I'd like to make.
Okay, you've used your time. You may take a minute.
Thank you, Your Honor. First of all, the only issue before this court is whether or not the OSPA and FERPA are applicable exceptions to the Ohio Public Records Act in this case. No other exception, for example, mental health records or disciplinary disability records, none of those exceptions have been raised. Those are inapplicable here. Second, to answer the Chief Justice's question, couldn't the state have written it the way we wanted it to? What they did, and what we know for sure about the legislature, is that they wrote it so that it would be in compliance with and follow the federal law, the Family Educational Privacy and Rights Act. So the statute should be interpreted consistently. That's exactly what this court has done in Souffrance, and there is no way that the worry for losing funding would be at issue because the Family Compliance Policy Office has issued the letter that says that this is how they should be interpreted. It lapses at death, and that's the same office that enforces FERPA. So for those reasons,
we are not bound by that. Would you agree?
I agree. You are not bound by that. It is not binding authority. However, under Lang, it should be deferred to where the statute is silent. And Ohio should not be an outlier and inconsistent with the way that the federal law is interpreted since it was enacted to comply with it.
Thank you.
Thank you.
Thank you. We'll take the matter under advisement and you'll be notified of our decision. Our last case this morning is 2020-229, Disciplinary Counsel versus Jason Allen Sarver. We have the relator here, Don Sheets, to argue on behalf of the Disciplinary Counsel, and oral argument has been waived on behalf of Mr. Sarver. Mr. Sheets.
Thank you. Good morning. Again, my name is Don Sheets. I'm here on behalf of Relator, the Office of Disciplinary Counsel. Today, we're asking you to overrule respondents' first 3 objections and instead adopt the board's findings of fact, its conclusions of law, and indefinitely suspend respondent from the practice of law with his reinstatement subject to conditions. As you stated, Chief Justice, the other side has waived. However, we wanted to appear just to highlight a few points and to answer any questions that the board might have. Respondent's first objection relates to the board's finding that he violated Rule 1.4. It's important to note that respondent conceded this violation at his disciplinary hearing. While testifying, the panel asked him about this exact violation, and he unequivocally admitted to violating Rule 1.4A1. We've cited the transcript in our brief. It's page 180. And as a result, this issue has already been conceded. And based upon that testimony and the rest of the evidence in the record, the board's finding with respect to that violation is well supported. Similarly, with respondent's second objection, he's now objecting to the board's finding that he violated Rule 3.4C. However, he stipulated to that violation before the hearing. He supported that stipulation during the hearing, and he continued to support that stipulation in his post-hearing brief. It's only now in his objections that he's for the first time objecting to this violation. Based upon respondent stipulations, his testimony, and the rest of the evidence in the record, the violation is well supported, and we ask you to overrule that objection as well. Respondent's third objection related to the board's finding that respondent's attempt at providing restitution didn't deserve mitigation credit. The board's finding was correct. We've cited cases in our brief that demonstrate that respondent's attempt at restitution was both untimely and ineffective. He only issued a check approximately a week before the disciplinary hearing. The check that he issued was not for the full amount, and it was to the estate when he understood that Allstate was going to reissue the same $50,000 a second time. Thus, any restitution negotiation or discussion needed to be made with Allstate and not with the estate itself. So based upon its untimely and ineffective nature, respondent does not deserve mitigating credit for his attempt at restitution.
Counselor, can I just clarify before you go on with more of your analysis? Is the board recommending disbarment or indefinite suspension?
That leads right into my next point. Thank you. The board is recommending disbarment. We recommended indefinite suspension at the board level. We're maintaining that recommendation today, although we acknowledge it is a close call. However, based upon our reading of the case law, this case more aligns with those cases receiving indefinite suspensions. Disbarment cases typically are more severe, and the cases that the board relied upon have some distinguishing characteristics, which I'll get to in a minute. However, we submit that this case is most akin to the Meyer case, which is discussed in our brief as well as the board report. These two cases, the instant case and the Meyer case, have similar underlying suspensions. So respondent had a 6-month actual suspension with a portion stayed, and Meyer had a 12-month actual suspension with a portion stayed. So there's that similarity. Additionally, both this case and the Meyer case involve similar misconduct between the two cases. So Meyer was suspended and then continued to practice while under suspension, was suspended for that, and then continued again practicing while under suspension. So there was that common thread through the Meyer cases. Similarly,
in both cases, did the respondent lie to the Supreme Court by filing affidavits, false affidavits?
They both lied, but in different ways. So Meyer lied in her first disciplinary case to relator. She denied practicing while under suspension. So by extension, lying to the court, as this office is an arm of the court.
And Sarver lied twice in the first case.
Sarver has lied quite a bit. You're correct, Your Honor. Yes.
A lot of lying going on.
And that's the continuing and common thread throughout Sarver's cases, just as Meyer had the common thread of practicing while under suspension, of ignoring suspension orders given by this court. Sarver has a thread of dishonesty that runs through all of his discipline.
Including filing a false affidavit with this court.
That is absolutely correct. That is absolutely correct. And make no mistake, we acknowledge that is serious and severe misconduct.
Well, let's talk about some of the others. What about from December 12th through March 29th, taking money out of the probate account for his own use on multiple occasions without probate approval?
That's absolutely correct. That is the basis from one of the 3.4C violations. And in fact, respondent stipulated to that. He stipulated to the conduct. He stipulated that conduct warranted a 3.4C violation.
And falsely signed the back of a check.
Absolutely, absolutely. We are talking about serious and severe misconduct.
And
he does not have the, I'm sorry.
And sent a release, a falsely signed release, to settle a lawsuit with the insurance company on November 30th.
Correct. He forged his client's signature on the check. Absolutely, Your Honor. You are correct.
And is, you know, it's a little confusing with the briefs. Is there money owing on restitution or not? And if so, how much?
$50,000 was paid. Respondent took that money, improperly dispersed it. When this all came to light, Juanita Mustin, his former client, retained new counsel. New counsel negotiated with Allstate, and Allstate agreed to reissue the same $50,000. However, at the time of the hearing, they were waiting on probate court approval, right? So they wanted to go through the correct process this time and ensure that there was probate court approval before issuing a second check. My understanding, I expect that process to be completed. I expect Allstate to graciously issue the settlement a second time, and I expect it to be handled properly the second time. However, there is the issue.
Counsel, what happens to the first $50,000?
Well, that respondent needs to repay. And
to whom?
Well, it'll be if Allstate reissues the $50,000 to the estate and everything goes as it should have gone the first time, then he needs to pay $50,000 to Allstate.
But hasn't there been some restitution?
Not yet. He did issue a check to the estate. However, the estate rejected that check because it would have endangered Allstate reissuing it. So they wanted to ensure that Ms. Mustin received that $50,000 from Allstate. So they rejected respondent's check.
So there has been no amount given to the estate, Ms. Mustin, the estate for the child. There has been no dollar amount.
As of the hearing, so Juanita Mustin had received approximately $4,200. It was an improper disbursement from respondent. Respondent met with her in December, in the month following his suspension, and gave her a disbursement, convincing her that it was okay. Essentially stating,
wasn't one of his arguments that she should give that money and back as restitution, and the additional $2,000 amount improperly dispersed to a third party, that they should be responsible for restitution of those amounts?
He testified at hearing that ideally, and his word was ideally, he wouldn't have to pay the full amount, that they would return the money that they improperly received. However, he indicated that if ordered to do so, if he had to bear that burden, he would reimburse the entire amount. And I think it's incumbent upon him to pay the entire amount. He knew what he was doing. He knew what he was doing was wrong. He convinced Ms. Mustin, who trusted him, that it was okay for her to take that disbursement. She should not have to return that money. He should be responsible.
Some more line.
Yes, absolutely. Absolutely. And that's why we're recommending an indefinite suspension. He does not have the requisite character and fitness as it stands today to engage in our profession. He doesn't. He has amply demonstrated that.
And yet the board is recommending a disbarment.
They are recommending a disbarment. We just read the case law and we agree it's a close call. This is serious misconduct. We're not asking for him to have a pass. He may never practice law again. And if he ever wants to, he needs to demonstrate that he has the requisite character and fitness. But looking at the case law, this appears to be more akin to the Meyer case than the cases that the board relied upon. So when you look at the cases that the board relied upon, there are a few things that stand out. The underlying suspension, the original suspension, was longer and for more severe misconduct. Or the respondents continued to pick up new clients even while under suspension. Or the following misconduct in the second case was much grander in scope than we're dealing with here. So if you look at Pryatel, Frazier, and Mbakbuo, those all involved originally indefinite suspensions. So those folks were indefinitely suspended for severe misconduct, misappropriating client funds, whereas respondent was on a 6-month actual. So that is a distinguishing characteristic that helps bring it in line with cases that have received an indefinite suspension. And if you look at Mbakbuo and Frazier had a 15-count complaint the second time. the scope of his misconduct the second time around was much greater. Mbakbuo had 4 years of misconduct the second time around when he was charged. Whereas, I mean, respondent's misconduct is severe. I don't want to miscommunicate with you. It is severe and it is serious, but it's a much smaller span than the cases the board is relying on. And if you look at the Fletcher and the Shaw cases, it's similar. Shaw had a 2-year actual suspension, much longer than respondent's original suspension. He continued picking up new clients. And when you read that opinion, it affected many more clients than a single client, as in this case. And similar with Fletcher, he continued practicing under suspension for 15 months, appeared in court, he lied as well. Just a greater scope of misconduct. And one further point with regard to Prietel, he came back and continued to contest the violations throughout the disciplinary process that deny that he had ever engaged in the unauthorized practice of law or practice while under suspension. Now, while we had some contested issues at the hearing, respondent in this case did stipulate to the vast majority of the facts, many exhibits, severe violations.
And then filed objections to things he had stipulated to.
He did, yes. That's absolutely right. You're absolutely right.
I don't see that as knowing that he did something wrong, then.
I agree. He has failed to acknowledge the scope and breadth of his misconduct, although he has acknowledged a great deal of it. He acknowledges lying to relator. He acknowledges filing the false affidavits, which contrasts with Prietel, who didn't get any of it and contested everything the whole way through. So we acknowledge it's a close call. We're not saying that this is in any way okay. It is serious and severe misconduct, and he may never practice again. He does not have the requisite character and fitness to engage in our profession as it stands today. However, in looking at case law that involves disbarment and indefinite, we analyze this case as being closer to the indefinite cases for the reasons that I've cited today, and distinguishable from the board's cases for the reasons I've cited today. If there are no further questions that I can ask, we'll rest on our briefs, but I'm happy to ask anything else, to address anything else that I can.
Thank you.
All right, thank you.
Thank you. We'll take the matter under advisement. You'll be notified of our decision. Marshall, will you adjourn court, please?
Hear ye, hear ye, hear ye. This open session of the Honorable Supreme Court of Ohio now stands adjourned.